So a couple of like I think it was 2 weeks ago. Um, I wrote that it was like very big news that Brazil had decided to join South Africa's case against Israel on the genocide of Palestinians. And I said that that was huge. And a lot of you asked me like, what? Why is it huge? And so, as a very big fan of Brazilian foreign policy. I thought we'd discuss this. What is going on in the world right now? Why is Brazil such a key player? And yeah, basically, why I think this could be an important turning point because of the way that Brazil is approaching the world right now. So just to contextualize, yeah, magic is like um, jumping the gun here, spoiler alert. So just to contextualize what's going on, right? So Brazil, as you all know, is a member of the BRICS. It is a um, you know, founding member of the BRICS, but it is also traditionally a Latin American state, which means that it has wobbled in a love-hate relationship with the United States for most of its history. So military dictatorship, love, love, love. Lula won, hate, hate, hate. Oh, hey, Bernhard, how are you? Um, and so um, much of what Lula has been doing as a matter of like foreign policy for more than a decade at this point has been to uh, make that Latin American aspect of Brazilianness be a little bit more in the past. Um, as in this idea that Brazil belongs in the United States' backyard, right? So in 2011, if I remember correctly, Brazil, under Lula in his first term, actually second term, decided to recognize the state of Palestine and essentially made Latin America um, en masse recognize Palestine as a way of signaling, look, we are not your backyard. We are an independent part of the world. We have our own concerns. We have our own thing, right, going on. And we, 2014, pretty sure it was before that, Jimbolo, but double check me. Um, and so, so Brazil basically then gives out this like aura of we are done being the backyard. We're going to be, I know we're Latin American, but we're going to be independent in our foreign policy. And the best way for me to signal I'm going to be independent in my foreign policy is to recognize Palestine. So there's a long history here of connections between Brazil and Palestine. So that's the first thing why I think it's important that Brazil is joining South Africa's um, case in The Hague. The second thing is that in this process of trying to figure out where Brazil fits in the world, I knew it was like earlier than 2014. In this thing where like we're trying to determine like what is a new Brazilian foreign policy like. This very influential Brazilian diplomat has been Minister of Defense, has been Minister of Foreign Affairs, and is now special counsel to Lula, to the President of Brazil, Celso Amorim, essentially carved a route right going forward of saying, look, Brazil has to become big, has to become its own pole of power. And so this is why it joins BRICS, this is why it recognized Palestine. Um, and now, in this new Lula administration, after uh, the Bolsonaro administration, which was basically the United States lapdog, it was pretty bad. Um, then Brazil is trying to like sort of take off. I remember there was this cover in The Economist in I think it was 2012, where like they show the Cristo do Corcovado, the Christ the Redeemer, um, taking off as if it was a rocket from Rio. I think it is now that's what's happening right now in the world. And the interesting thing is, in a world that is tending towards multipolarity, Brazil appears like the biggest democracy with a chance of becoming a significant pole of power in world order. And I mean this in the sense of like, so for example, Brazil was trying to expand the BRICS, and there was an internal debate within the BRICS of what should the new expanded BRICS be? Should it be a club of anti-Western states, or should it be a separate organ, multilateral organ with a parallel way of dealing with the world? So should the BRICS define itself on the basis of opposition to the West, as like Russia wants, um, or should it be, and to a degree China, or should it be a separate parallel pole as India and Brazil wanted and South Africa wanted? And so Brazil sort of lost that battle. The BRICS admitted a bunch of states that pretty much put it in a course to be like in contention with the West, like including Iran, for example. But Brazil could have, like, Brazil had the option of saying who's coming into the BRICS, and they could have said Venezuela, the logical anti-Western option, right? Solid left winger forever. No one's gonna remove Maduro because Maduro is an authoritarian that like stays in power forever. No, they said no. Let's include Argentina, and then Argentina, being a democracy, elected Milei, and so Argentina rejected Brazil's invitation to the BRICS because of ideological reasons. And so Brazil ended up like with no Latin American body in the BRICS, let's say. So it was sort of like a difficult moment for Brazilian diplomacy, but it was a, let's say, quote unquote, a worthy cost, because Brazil wanted a democracy in the BRICS, not an authoritarian government. So it was a very mature decision by Brazil. Um, and it sort of tells you what kind of world Brazil is trying to create, right? Um, and so when you factor this idea of Brazil as the bringer or the proponent of a post-Western world that isn't essentially, it's now, I think of it in the terms like Putin, right? What does the world order look like for Putin going forward? And I think it's pretty clear that for Putin, a new world order that satisfies his worldview is, well, whichever world order that allows me to now be the one who bends the rules to my favor. That's the new Putin way of doing things. This is what explains the war in Ukraine, right? Violating one of the cardinal rules of international law, um, and denying Ukrainian self-determination. Um, or China. China is not as brazen as Russia, but it does have this notion of like, look, we entered the international arena in the 19th century as an other. The Chinese speak of their century of humiliation. And so what China basically says is there will never be another century of humiliation. That is the main cardinal rule. Once you understand that, you understand Chinese foreign policy. So China has been like, oh yeah, we're fine enriching ourselves through trade and through assuming lending money to the U.S. But if you want to start a trade war with me, what was the Chinese response? The Chinese response was like, hey, we're ready, bring it. We'll destroy you. Bring it. And they elevated the temperature of their U.S. Relationship almost immediately, as if like, oh, this is it. This is when the century of humiliation um, turnaround is going to come. Like they will want to subjugate us, and we will not let them. And this will be the moment when we will be able to like push back and use all of that power that we have accumulated over the years, economic and political power, to like flex our muscles and be the new powerful hegemon in the region, in the world. Right, that's China. Brazil is sort of not like that. Brazil follows more like the South African path. It's like, oh, there's a genocide happening in the world. Okay, let's go to the ICJ. Right. Um, so Brazil is the one that's saying like, I mean, whatever flaws, and I do think that there are flaws in Lula's approach to Putin and to like the war in Ukraine. Um, they've stumbled a little bit in trying to balance out this like idea of defending um, non-alignment and being in the BRICS at the same time. So they've made a few mistakes here and there. Overall, their proposal is like, look, there's an economic side to this war, which is countries all over the world are struggling because there's no grain, there's no food coming out of like one of the world's biggest bread baskets. That is a relevant thing to discuss, and therefore the war must end. Um, and they've offered themselves as negotiators to end that war. I have my own problems with that, in that I don't think that a negotiated end to the Ukraine war is reasonable because it's a war of aggression. Um, but it is still, this notion of at the very least stop the war, sit and negotiate. I can work with that. I wish they were a little bit more categorical on the terms of that negotiation. Lula has had some unfortunate um, arguments about Zelensky. I disagree with him on that. Um, but overall, it also signals Brazil's attempt at like getting involved in these like quote unquote big power discussions, right? And so you have this country that is like very ready to assume its like big role in the world. And recently, the United States under Trump sanctioned Alexandre de Moraes, who's a Supreme Court justice in Brazil, who is basically leading the equivalent of the January 6th event in the United States, but for Brazil. Um, So Cherenkov says, to me, South African approach means secretly make a nuclear weapon and never announce it, but that's just my special interest. That sounds more like the Israeli approach. um, so, oh hey, Konikos, how are you? Just saw you there. Um, but anyway, so the United States imposed sanctions on the Supreme Court justice, which, just to begin with, right? If you are a state that has the power to impose economic sanctions on another country's Supreme Court, you are too powerful, right? You're way too powerful. Like if you have the power to make judges lose access to a debit card, because that, I mean, um, when the United States sanctions you, and I've discussed this with you guys before. Like I have a friend, Judith McIntyre. I have a friend who has been sanctioned by Russia and just moved on with their lives. But when the United States sanctions you, all U.S. persons need to stop trading with you, and so you lose access to a debit card because Visa and Mastercard are U.S. persons. Your banks cannot operate with you because SWIFT is U.S. company. Or because banks need to do business with the US, so like you can't really have a bank account. When that is something that can happen to you, then something is wrong, right? So you have too much power, and then the immediate incentive for states all over the global South is to divest away from U.S. financial interest and U.S. orbit, because honestly, there is no it becomes a matter of national security. There's no security, there's no rule of law if a country can say, no, 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 you know what? I want you to declare that the people who try to take power in a coup are innocent, and until you say that, I will sanction your Supreme Court. That's insane. That's ridiculous. Um, so Cherenkov says, it seems pretty likely that South Africa did help Israel test their bomb. Actually, also did do know South Africa had a nuclear weapon. I actually didn't know that South Africa had a nuclear weapons program. Um, but if you do that to this kind of country, to Brazil, then the immediate thing that will happen, just as it recognized Palestine in 2011, is it will invest considerable diplomatic efforts in trying to divest away from the dollar, divest away from SWIFT, divest away from, Visa, Mastercard, SWIFT, all of the financial institutions in 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 the world that are tied to the United States. And I mean, this is something that always, like, I'm Peruvian, right? So in Peru, small country, our constitution is a little bit weird in that I have a constitutional right as a Peruvian citizen to hold foreign currency. Right? So I can have a dollar account or a euro account or a pounds account in Peru. And that's like, constitutionally protected under the constitution, because we had like our own like hyperinflation problems back in the 80s. So the response was to say, okay, you can protect your finances by having a foreign currency account in your own country. That is something that whenever I discussed it with my Brazilian friends, they were like, "What? That is crazy! Like, how can you have a dollar account in Brazil?" And I learned that was like not that common actually. So Brazil is already sort of divested already from the US, and that it was interesting to see the United States impose tariffs on Brazil. It's like tariffs. I mean, sure, there is about 12% of Brazilian exports going to like the US, but I'm not so sure that they would be that effective, because like in Brazil, Brazilians have their own brand for everything. Like think of an American product, like a US product, and Brazil probably has a local replacement that Brazilians like more. Like if you like, I don't know, if you like Shake Shack, there's a Brazilian Shake Shack called New Doggy that's amazing. If you like McDonald's, you can do Bobby's, which is also amazing. And so I'm not sure that the tariffs will be like that catastrophic for Brazil. Maybe they will. I don't know. But again, you've torpedoed a relationship with Brazil at a moment where Brazil was already saying, "Hey, maybe we should divest away, and maybe we should move to a post-Western world." So um, when you set this context, when you set out this context, and then you say, "Oh, Brazil is intervening in the South Africa case," I get very excited, because I feel like they can do to the whole discussion on genocide what they are trying to do to the world, to current world order right now, trying to like divest away from the US centered world order. And I say this because and I'll get to this in a second, but I'll say this because there's a longer history of Brazilian international law and foreign policy when it comes to genocide, and I wanted to discuss that with you today. So that's basically what I'm going to do. So I'm going to set the scene a little bit, and then we're going to go into reading a couple of like legal decisions, judicial decisions at the ICJ that I think might be able to contextualize why I'm so excited about Brazil intervening in the South Africa case. Okay, let me catch up with the chat. So Adara says also they should never have this kind of power or for over foreign countries handling their own business. Yeah, I mean, I think in this era of imperial collapse that the United States is entering into right now, they are sort of drunk with power. Um, there was an understanding for after the end of the Cold War, where the United States would be extremely powerful, but it would use that power with some measure of um, unwritten rules. Um, the United States sanctioning a UN Special Rapporteur was unthinkable 10 years ago. The United States sanctioning a Supreme Court judge with the Magnitsky Act, which is like this act that sanctions human rights violators, was unthinkable like 5 years ago. Right, so there's this process of imperial collapse in the United States that is making it think that it doesn't need the world. Um, Mostly because I think my evaluation of this is um, the U.S. imperial model is premised on the idea that things need to be cheaper and poorer quality forever, and that people need to have lower salaries and higher costs increasingly, right? And so that is an unsustainable model. And so while American citizens were, like US citizens were for a long time willing to sustain this incredible international apparatus to maintain a world order where they were number one, I don't think that is what they care about anymore. I think they care about one of two things. Either they care about, you know, increasing salaries and lowering costs, which is what explains what Sohran Mamdani is why he's winning in elections, or why um, like politicians like that are starting to appear here and there, or even why the MAGA base is just saying I don't care about Israel and going to watch Tucker Carlson um, on this, right? Or they are so frustrated with their current affairs. They are so like depressed in the economic sense, like economically depressed, have so little options. There's no American dream anymore. That every now and then they need an uptick of like, hell yeah, we're number one still. They don't really feel number one anymore because they are impoverished, but they need the boost. So they need to say, ha, see, we can sanction Brazil with 50% tariffs and sanction the Supreme Court. Ha, we're so powerful. We're amazing. We're number one. Hell yeah, USA, right? But it's sort of in doing that, in maintaining either that idea of like, no, let's bring things back to the domestic front again, and or let's feel empowered through symbolism, not through actual empowerment. The United States is destroying its own empire, right? So they are out of control. They are deploying their power in ways that are irresponsible. Like the United States cannot simply just pick a fight with Brazil at this point in time. It needs Brazil as the leader of Latin America, if it wants Latin American votes in the UN or anything like that. And also, like again, it. I have this belief, right? Like, rules have value because people believe that they have value. Why is it that you stop at a red sign? Because you believe that stopping at a red sign is the right thing to do. If you didn't, and believe me, I'm Peruvian, so most Peruvians don't think that stopping at a red sign is valuable. It isn't binding, right? And so the same goes for world order. If the United States can sustain itself as the hegemon of the world, because of these like unspoken arrangements, or oh, I'm not gonna deploy this power in this way, I'm gonna deploy it in this other way. If that's going out the window, then states are going to look for alternative sources of power. Okay. Oh, the chat is very active today. This is interesting. I don't usually expect Brazil to like be the object um of so much chat activity. Iconoclast says, but this power brings with it arrogance, and arrogance prevents them from seeing the world turn away from the dollar and trying to find ways not to be dependent on. Yes, exactly. I agree. So, Cherenkov says, by the way, my Peruvian friend told me you're going back to the Fujimori times. Don't talk to me about Peruvian elections. Not. We can do a stream on Peruvian elections. They're coming next year, and I don't know who to vote for. They all suck. Yeah, no. We'll one thing at a time. I hope Fujimori doesn't win this time around. Like Keiko Fujimori. Ikaraka says they think they can bully the world into remaining US dependent, but the more they try, the more countries look for new allies. Yeah, this is exactly what's happening with Brazil. So Lady Bros says, I'm very much wanting to keep on topic, but at the same time, I'm very curious about your opinions on France, Canada, and potentially UK, Australia, Germany, recognizing Palestinian statehood. Do you think you'll make a video on that at some point? I will, and if I have time before the end, I can talk about it briefly, today. If not, I will be discussing it no matter what, so don't worry about it. Eventually, we'll talk about it. Yeah, so to give you an idea of where things stand in Brazil, I have this, like, where is it? So I don't know if you can see this. Yeah, you can see this. So this is João Moedo. João Moedo is like, how can I describe João Moedo? He is a libertarian. He leads a party called Partido Novo, like New Party, which is supposed to be very libertarian. Imagine, imagine what's it called, this guy, this libertarian guy that wants to like leave the UN in the US. Anyway, a very, 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 very libertarian guy. And I think I can translate this. Hold on. So I don't trust Grok translating, but let me read it in English for you guys. So this is like, this would be a Lula enemy, right? This is a guy that would hate Lula. And say, the application of the Magnitsky Act to Minister Alexandre de Moraes is an unacceptable attempt at external interference in Brazilian justice. The Brazilian judiciary, more like it. Brazilian politicians who celebrate this decision or remain silent make it clear that they do not respect our sovereignty and have no plan for Brazil. They are merely opportunists with personal projects for power. They do not deserve to be elected or hold public office. Right, so this is like Lula's rival, right? Like not the authoritarian right wing, but the libertarian right wing. And yeah, um, this is um, this is a situation here where the sanctions, the tariffs, have united Brazilians against the United States in a way that I don't think the U.S. understands. Um, so uh, so Liberals, libertarian left or right? So I think what you're referring is to liberal left or right. Like in Latin America, liberal refers to classical liberal right winger, and the extreme classical liberal is a libertarian in Latin America. In the United States, liberal refers to a progressive center, center left. So I don't know of a libertarian left winger. um, so So yeah, yeah. As Magic says, he probably got Lula reelected, like Trump. So this is the situation in Brazil, right? This is Oliver Stunkel, who's a very good Brazilian academic. He writes about how Brazil is trying to bring about the post-Western world, right? And he says, it's in Portuguese. Hold on. I hate translating to grok, but okay. An element of excessive uncertainty has settled into the bilateral relationship with Washington, which forces Brazil to accelerate the process of diversifying partners to reduce its exposure to the U.S., not only in the commercial and financial spheres, but also in the technological and military ones. So this is like a very influential guy saying, yeah, we need to move away from the United States. Um, so just to give you an example, I saw so for example, he says he's talking cloud computing here, like, oh, what happened? It is also essential to reduce the use of US cloud and software in public services and banks. As Lemos Ronaldo reminds us in Folia, 60% of Brazil's digital load is in data centers in Virginia. It is time to invest in national solutions. In defense, there's a software dependency. In defense, there's dependency on software, sensors, and intelligence from the United States. A cut in support would harm sovereignty. Brazil must diversify suppliers. France, Germany, India ensure reserves and train with new partners. Um, so essentially, what's going on is the entire country of Brazil is saying like to hell with the United States, and it's not a partisan issue; it's a national issue. Like to hell with the United States, let's do our own thing. So this is not just re-electing Lula; it is catapulting Brazil to a new kind of foreign policy. It's always tried to be, since Lula won, it's always tried to be its own thing. Now I think it's going to invest in becoming a bit more of a worldly player, to have these like domestic solutions to be independent in the world that we live in, and that is something that we have never seen a Latin American state do before. So I'm very excited to see what goes on, because Latin American foreign policy is usually from the perspective of the little guy that uses the law to try and control um, damage, to do damage control. Don't invade me because here's international law. And Brazil is basically saying, no, no, no. What we need is to be our own thing. We need to be independent from the United States. This is something that we have not tried in the region before. It is interesting to see it develop this way. So I just wanted to share this because like Davison Belém Lopez, who's a friend of mine who works in UFMG, was the University of Minas Gerais, shared this article by Celso Amorim, this very influential guy in Brazilian foreign policy, where I'm gonna try and translate this like really from Portuguese, at least the parts that are important. But so he says, so he talks about how creating the G7 was a failure of multilateralism. It turned the world into like a little club of 7 states, and how the world never recovered from that, right? And there's a paragraph around here that I wanted to read to you. Um, a, um, a, 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 so talking about the BRICS, a distinctive characteristic of BRICS, it's its focus on practical solutions for the necessities of a world in for the developing world. In 2014, the BRICS established the new development bank that significantly amplified the offer of public financing, particularly in areas of infrastructure and sustainable development. Um, we also advanced crucial discussions on commerce in to do commerce in local currency, right? Investment flows, cooperation in AI, and climate action. Um, BRICS was not conceived as a rival of G7. However, uh, ever more, it offers something that the old order does not achieve: inclusion instead of exclusion, reform instead of stagnation. Today, its mission is to channel this impulse to construct a world that is just and sustainable, where multilateralism prevails. We do not need anything other than that. And I feel like this is like the path that Brazil is charting for itself, right? And it's a very interesting one. So let's move from geopolitics, this context, to what Brazil can do in this South Africa case, in this genocide case against Israel, right? Because just like Brazil has a specific context in geopolitics, in the history of the definition of genocide, it also played a key role because there was a very important judge in the court when the court decided, all of these debates that we've been having on the only reasonable inference test and whether the definition of genocide is narrow or broad, and all of this was done at a time when there was a Brazilian judge in the court. And this Brazilian judge wrote a relatively famous dissent on the Serbia v. Croatia case, where he opposed what the court did. And he said the court should not have closed the door to the finding of intent in the way that it has. The court uh, should have taken a broader approach. And so I imagine that a Brazilian foreign policy that is trying to do what we just discussed about, like decentralizing world politics, would probably try to revive this way of doing international law, which is, let me put it in the screen, um, here, Judge Antonio Augusto Cançado Trindade, who's a behemoth of Latin American international law and particularly of the Brazilian tradition of international law. Very different from the current Brazilian judge, mind you, at the court. Current judge is more traditional. This guy was very much about transforming international law from a state-centric set of rules to a set of rules focused on the protection of the individual and human rights and people. So it was really something. And so I wanted to read with you um, his um, his dissent in the case of Serbia v. Croatia, as a way of understanding what can Brazil bring forth to the discussion on genocide, if as I believe they should, if they bring in these kinds of ideas to the discussion. Because the discussion so far on the genocide case has been more like, okay, Amnesty International, Human Rights Watch, B'Tselem, they have all sort of like said, look, from the perspective of what the ICJ did in 2015, like in this case, we can find genocide in Gaza. That's what the all of these like reports that have come out say. Now, we would like the court to be more reasonable in its interpretation of the rules, take into account context, take into account, whatever you want to say, in terms of like the colonial context of Israel-Palestine. But the court does not need to, because just with what the court did in 2015, we have enough, right? It's like 60-70% traditional established law and 40%, 30% pushback. right? Or at least request to go further than that. The only exception so far has been Ireland, and I made a video on Ireland and their position on genocide, but I don't think it's a very good position. I think they are indeed trying to change the definition of genocide to make it a crime that can be committed through negligence, and I'm not exactly sure that that is, the best way to go. I don't think we should be in the business of saying that you can commit genocide by oopsie, right? I'm open to to see what happens with what Ireland is suggesting, but I don't think it's the best intervention so far. Uh, Ireland's, and I think if Brazil focuses on these kinds of ideas that we're going to read in a second, then we can then sort of see a different kind of pushback, not a whatever we do, we don't need to go further than what the court did in 2015, but saying actually what the court did in 2015 was one option of all the possible options to resolve this situation. It was one option, and what Cançado Trindade said was another option. And why don't we explore that, considering that, I mean, clearly the law on genocide is criticized by everyone basically as a law that is too narrow. Um, and you can say even with the narrow definition that we have today, um, that was narrowed by the ICJ in 2015. You can still find genocide in Gaza. I did it. I made a video on how you can do that. So I don't think that's a problem. But in that 30 or 40% pushback that others are doing, I would like to see this Brazilian tradition incorporated into Brazil's position, Brazil's intervention in the case. Oh, geez, Steve, I just saw that you subscribed, so thank you for that. Appreciate that. Resubscribed, actually. So let's start. Okay, let's start reading because I have like 30 minutes to do this. So essentially, the main thing that Cançado Trindade did that the other judges did not do is he had been the president of the Inter-American Court of Human Rights for a decade, I think, by the time he was then transitioning. He then transitioned to the ICJ. He went on from being the leading judge at the Inter-American Court of Human Rights to being the constant dissent at the ICJ. Like, other judges didn't really agree with him, but I feel like that his role as a dissenter has been very important. So in his dissent, he went like, okay, why don't we look at what human rights tribunals, particularly the Inter-American Court of Human Rights, have said about the standard of proof to determine that there is a plan or intent in the commission of atrocity crimes, and we should use that for the finding of intent at the with the convention with the Genocide Convention. Right, so he says the case law of international human rights tribunals is of central importance to the determination of the international responsibility of states for grave violations of human rights and cannot pass unnoticed in a case like the present one. And it did. The court ignored it completely. Right. Where is it? Hold on. Okay, so the case law of the Inter-American Court of Human Rights is particularly rich in respect of the standard of proof in cases of disclosing a systematic pattern of grave violations of human rights. In the case of Juan Humberto Sanchez v. Honduras, for example, the IACTHR determined the occurrence in that respondent state in the 80s and the beginning of the 90s of a systematic pattern of arbitrary detentions, enforced disappearances of persons, and summary and extrajudicial executions committed by the military forces. The Inter-American Court thus inferred, even in the absence of direct proof, that the victim suffered cruel and inhuman treatment during the time of his detention, before his mortal remains were found. The facts that occurred at the time of the pattern of ill treatment and torture and summary executions led the AICTR to the presumption of the responsibility of the state for those violations in respect of persons under the custody of its agents. This being so, the court added, it was incumbent upon the respondent state to provide reasonable explanations to what occurred to the victim. So it's the other way around, you see, like the state needs to explain how did this person end up being tortured or being like executed, not the party making the claim. So if you translate that into a case like Gaza, it would be Israel that would need to say, how is it that 50, 60,000 people died in Gaza, right? Let me continue. Hold on. I'm trying to get to the summary. It's here. So then he says, as I have just indicated in the present dissenting opinion, international human rights tribunals have not pursued a stringent and high threshold of proof in cases of grave violations of human rights. Given the difficulties experienced in the production of evidence, they have resorted to factual presumptions and inferences and have proceeded to the reversal of the burden of proof, meaning that the state needs to prove that it did not commit a violation, rather than people who claim that there's been a genocide claiming this was a genocide. The Inter-American Court of Human Rights has done so since the beginning of its jurisprudence, and the European Court of Human Rights has been doing so in more recent years. They both conduct the free evaluation of evidence. So he's saying, like, this is something like what Judge Nolte said in his dissent in the provisional measures judgment of the South Africa case. And like, oh, there's such a high burden that South Africa needs to meet to show who is actually demonstrating intent, who is actually demonstrating a pattern of conduct that leads to genocide, right? And what Judge Trindade is saying is, it should not be that high that you cannot demonstrate that genocide exists. Right? So he says, the standard of proof they uphold is surely much less demanding than the corresponding one beyond reasonable doubt in domestic criminal law. This is so with all the more reason when the case lodged with them disclose a pattern of widespread and systematic gross violations of human rights, and they feel obliged to resort even more forcefully to presumptions and inferences to the ultimate benefit of the individual victims in search of justice. This important issue begins to attract the attention of expert writing in our days. So the argument he's making is like, what is the point of all of this? The point of all of this is to bring justice to victims. If you establish a criminal prosecution level analysis, then you will not bring justice to the victims, because in cases like this one, states have so much potential to hide evidence that they will not that they will be able to hide that evidence, right? Regrettably, none of these jurisprudential developments was taken into account by the court. It is my understanding it could and should have done so, as the issue was addressed by the contending parties, as from the moment in the proceedings I put a question to both of them in this respect. The International Court of Justice preferred to stick to a stringent and high threshold of proof in the present case concerning the application of the Convention Against Genocide, just as it had done 8 years ago in the Bosnian genocide case. May I here only add that expert writing dwelling upon the complementarity between state and individual responsibility for international crimes, despite their distinct regimes, has likewise been attentive to the orientation and contribution of the case law of international human rights tribunals, like the Inter-American and European one, particularly on the handling of evidence and the shifting of burden of proof. So he's saying, like, you ignored Inter-American law, European law on the standard of proof, and that meant that you didn't find the genocide because you put such a high standard for the production of evidence that you missed the genocide, right? Here as well, he also looks at international criminal tribunals. And I'll get to a point soon, you'll see, where he says that circumstantial evidence is important to determination of intent. Let me get to the bottom of it. Hold on. So he says, the jurisprudence of international criminal tribunals thus clearly holds that proof of genocidal intent, this is what we've discussing with the case of Israel for a very long time, may be inferred from the aforementioned factors, such as inter alia the plan or policy of destruction, pertaining to facts and circumstances. So essentially, how many people you've been killing and stuff like that. Right? Even in the absence of direct proof, the finding of those factors may lead to the inference of genocidal intent on the part of the perpetrators. In the present case of the application, blah blah blah, opposing Croatia to Serbia, the contending parties themselves have made arguments in relation to the question whether genocidal intent can be proven by inferences. For example, Croatia argues that the parties also appear to be in agreement that the court can draw proof of genocidal intent from inferences of fact. It further argues that Serbia acknowledges in the Contra Memorial that it is sometimes difficult to show by direct evidence the intent to commit genocide as the mental element of the crime. The respondent goes on to refer to the possibility of reliance on indirect evidence and drawing proof from inferences of fact. This is what the court did then with the only reasonable inference case, the only reasonable inference test that it used to narrow down how to infer that intent. May be recalled that despite all the aforementioned indications from the case law and the international criminal tribunals, the International Court of Justice held in this respect in the earlier 2007 case that the dolus specialis, and this is the only reasonable inference test, the dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to a particular circumstances unless a general plan to that end can be convincingly demonstrated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent. That this is the only reasonable inference test that we've talked about before in this channel. This is Cançado Trindade saying here, the ICJ seems to have imposed too high a threshold of evidence for the determination of genocide, which does not seem to follow the established case law of international criminal tribunals and of international human rights tribunals on standard of proof. The court seems to have set too high a standard for finding the Serbian regime in time of war in Croatia complicit in genocide. Even when direct evidence is not available, the case law of contemporary international tribunals holds that intent can be inferred on the basis of circumstantial evidence. And so what Cançado Trindade here is saying is the only reasonable inference standard is that it's a judicial invention by the ICJ that wanted its own test. But what Cançado Trindade is saying is that test does not reflect a good faith interpretation of the jurisprudence of the case law of human rights tribunals on the one hand and international criminal tribunals on the other. Right? So you should not just infer intent from this like single-minded, the only possible inference of this pattern of conduct is genocidal intent. He says, ultimately, intent can only be inferred from such factors as the existence of a general plan or policy, the systematic targeting of human groups, the scale of atrocities, the use of derogatory language, among others. The attempts to impose a high threshold for proof of genocide and to discredit the production of evidence, like for example witness statements, are most regrettable, ending up in reducing genocide to an almost impossible crime to determine and the Genocide Convention to an almost dead letter. This can only bring impunity to the perpetrators of genocide, states and individuals alike, and make any hope of access to justice or on the part of victims of genocide fade away. Lawlessness would replace the rule of law. So I fundamentally agree with this. I think that this is what the court did. It narrowed down the definition of genocide through technicalities, through legal technicalities. And I feel like Brazil participating in the South Africa case can bring this kind of language back into the discussion, back into the only reasonable inference test is just that, it's a test. This is something that Canada, the Netherlands, Denmark, the UK, and I think Germany also said in the Gambia v. Myanmar case. They said the only reasonable inference test is just that, it's a test. You can use others, courts. And so now, of course, they're scrambling because they don't know what to do, because if you apply that standard to Gaza, then you find genocide, and they don't want to find genocide in Gaza. But the reality is that so far, most of the reports that have come out on why this is genocide have been on the language of, well, if we use this very narrow concept of genocide, this is very narrow interpretation of the concept of genocide that the ICJ produced in 2015 and in 2007, we can find genocide in Israel. That's what I did in my video. That's what Human Rights Watch has done. That's what B'Tselem has done. That's what Amnesty International has done. Without pushing back on saying like, but why do we need to use this test? Really, like why is this sacred? There's no precedent in international law. This is not the common law. You can change it. So this is what Cançado Trindade is saying. Another word of caution, he goes on, is to be added here against what maybe appear as a regrettable deconstruction of the Genocide Convention. One cannot characterize a situation as one of armed conflict, or war, so as to discard genocide. Again, I don't think that enough people are saying this in the context of Gaza. The main argument of Israel is saying, like, this is an armed conflict, the regrettable choices that we have to make mean that we have to kill 60,000 Palestinians because of the requirements, the necessities of war. And what Cançado Trindade is saying is like, no, 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 you should not conflate both. The two do not exclude each other. You can commit genocide while you are undertaking a war. In this connection, it has been pertinently warned that perpetrators of genocide will almost always allege that they were in an armed conflict and their actions were taken pursuant to an ongoing military conflict, yet genocide may be a means for achieving military objectives just as readily as military conflict may be a means for instigating a genocidal plan. So this is like very important to bring into the Gaza discussion. So Chirimbolo says, didn't the legal teams that took Myanmar to trial said that the only reasonable inference standard is unrealistic? I don't know. Maybe I haven't followed the hearings to that level of detail, but like maybe. I think there is growing consensus that this test should only be seen as a test. I'm sure the Gambia will make that argument. So Judge Trindade starts to look at what Serbia did in Croatia, and starts to find these patterns that he says like, hey, this should lead you to believe that this was a genocide, regardless of whether it is the only reasonable inference, because we accept that you can commit genocide during an armed conflict. Right? So he says, widespread and systematic pattern of destruction, mass killings, torture, beatings, systematic expulsion from homes, and mass exodus and destruction of group culture. So these are the things that he looks into to say this is a genocide, right? So he says, an examination of the factual context as a whole, which, you know, makes me think of Francesca Albanese's report on the triple totality angle to genocide, discloses a widespread and systematic pattern of destruction carried out in villages brought to the attention of the court in the course of the present proceedings. Such a pattern of destruction, as it will be shown next, encompasses massive killings, tortures and beatings, systematic expulsion from their homes, and mass exodus and destruction of group culture. So you can see the parallels with Gaza, right? After reviewing and assessing the occurrence of those crimes, I shall move on to other manifestations of the widespread and systematic pattern of destruction in the attacked villages in Croatia. So of course, I'm not going to go into indiscriminate attacks because I don't have time, or torture. There's one section that I want to talk to you about. Here, systematic expulsion from homes and mass exodus and destruction of group culture. In addition to mass killings, torture, beatings, and other mistreatments, unbearable conditions of life were inflicted on the targeted Croat population. There were systematic expulsions from homes, just like in Gaza, the imposition of subsistence diets, just like in Gaza, and as in Israel just calculates how many calories is needed per capita in Gaza, and that's it, and then obviously starves the population, and the reduction of essential medical treatment and supplies, as in Gaza. The targeted segments of the population were required to display signs of their ethnicity, which is not needed in Gaza because everyone is a Palestinian, and were denied food, water, electricity, and medical treatment, just like in Gaza. Right? Their movements were restricted, and they were subjected to repeated lootings and to a regime of random and mass killings, literally like in Gaza, including the repeated looting of like underwear. Amidst brutalization and extreme violence, their cultural and religious monuments and the signs of their cultural heritage were destroyed or looted, just like in Gaza. The basics of education was suppressed. They bombed universities in Gaza, so as to be replaced by education as Serbs. How many times have we heard that part of the plan that Israel has is to like re-educate Gaza, right? There was expulsion or forced displacement of the Croat population for the villages of blah, 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 blah. People were forced to sign statements relinquishing all rights to their property and to embark on mass exodus. Those who did not do so were subjected to a brutal regime of extreme violence. Croatia recalled that the ICTY, in Kristić's case, found that where there is physical or biological destruction, there are often simultaneous attacks on the cultural and religious property and symbols of the targeted group, as well as attacks which may be legitimately considered as evidence of an intent to physically destroy the group. So again, this is Cançado Trindade saying, if this is happening, you should see this as a genocide. The ICJ itself cited these findings in its 2007 judgments. It is clear that the destruction of cultural and religious heritage as occurred in the present case, can be of significance within the context of the widespread and systematic pattern of destruction as occurred in the cas d'espèce, opposing Croatia to Serbia. Such destruction of cultural and religious heritage is not to be simply dismissed to court as the ICJ has done in the present judgment, because the ICJ said like cultural genocide is not genocide, therefore we cannot evaluate this as genocidal, which is bonkers, right? So Cansado is saying don't do that, and I would say to Brazil, say the same thing for Gaza, don't do that. Don't just omit cultural genocide is not in the Genocide Convention and therefore it doesn't matter. Don't do that. It does matter. It's a sign of intent. It should have taken into due account the aforementioned pattern of destruction as a whole, encompassing destruction of cultural and religious sites as properly warned by the ICTY in the Krstić case. In the present case, Serbia, for its part, retorted that for the systematic expulsion of peoples from their homes to fall under Article 2C of the Genocide Convention, so the conditions of life, item, it must be part of a manifest pattern capable of affecting the physical destruction of the group, not merely its displacement elsewhere. In its view, the applicant failed to prove that the expulsion of Croats where it has occurred was accompanied by the intent to destroy that population. So this is the discussion that I had with you guys on my previous stream, where we talked about the difference between ethnic cleansing and genocide. So the court said that ethnic cleansing can only be genocidal when you can find that like intent to destroy within the ethnic cleansing campaign. And what Cansado is saying, like, whoa, wait a minute, isn't ethnic cleansing itself a hint that this is genocidal? So in addition, Serbia minimized the relevance of the destruction of cultural and religious objects, saying that in the drafting history of the Genocide Convention, the inclusion of attacks on cultural and religious objects under the rubric cultural genocide was discarded in the course of that drafting process. On this point, may I observe that in his autobiography, Raphael Lemkin, who devoted so much energy to the coming into being of the Convention Against Genocide, warned that genocide has been an essential part of world history. It has followed humankind like a dark shadow from early antiquity to the present. To him, a group can be destroyed as a group even when its members are not all destroyed, but its cultural identity is. Genocide, to Lemkin, means also the destruction of a culture, impoverishing civilization. The destruction of the cultural identity of a group destroys ultimately its spirits. Lemkin confessed that the idea of cultural genocide was very dear to him. Lemkin much regretted that there was no support for this idea in the Travaux Preparatoires of the Genocide Convention, but he kept nourishing the hope that in the future an additional protocol to the Convention on Cultural Genocide could be adopted. Where am I? Skip. Okay. The evidence produced before the court in the present case clearly establishes, in my perception, the occurrence of massive killings of targeted members of the Croat civilian population during the armed attacks in Croatia, amidst a systematic pattern of extreme violence, encompassing also torture, arbitrary detention, beatings, sexual assaults, expulsion from homes, and looting, forced displacement and transfer, deportations, and humiliation in the attacked villages. It was not exactly a war. It was a devastating onslaught of civilians. It was not only a plurality of common crimes that cannot in itself constitute a genocide, as counsel for Serbia argued before the court in the public sitting of blah blah blah. It was rather an onslaught, a plurality of atrocities which in itself, by its extreme violence and devastation, can disclose the intent to destroy mens rea of genocide. You can see how Cançado Trindade is therefore constructing a different kind of test to finding genocidal intent. Right? He's not saying, well, is it the only inference that you can make? He's saying, no, if you look at the whole thing, which is similar to what Francesca Albanese says, if you look at the whole thing, then it has to be genocide. This is more in line to what I understand the test to find intent to destroy should look like. This is, again, lege ferenda. This is the law as I would want it to be, not the law as it is. Right? The law as it is very narrow through this invention by the court. The atrocities were not seldom carried out with the use of derogatory language and hate speech. I find it important to stress the circumstances surrounding the attacked population, which was left in a situation of the utmost vulnerability, if not defenselessness. Such situation constitutes, in my understanding, an aggravating circumstance. Later on in the present disinterpretation, I shall return to the blah blah blah. But last but not least, may I here add that in this factual context, the expression ethnic cleansing seems to try to hide the extreme cruelty that it enshrines in referring to the pursuance of the utmost violence of a forced removal of a targeted group from a given territory. I have already referred to that rather surreptitious way whereby ethnic cleansing penetrated the legal vocabulary as a breach of international law. It so happens that such coerced or forced removal of a group from a territory so as to render this latter ethnically homogeneous has not seldom been carried out, as was in the former Yugoslavia, as the wars in the former Yugoslavia show, by means of killings, tortures and beatings, forced labor, rape and other sexual abuses, expulsion from homes and forced displacement, and deportations with mass exodus, and the destruction of cultural and religious sites. Thus, what had initially appeared to have been an intent to expel a group from a territory may well have become, as extreme violence breeds more and more violence, an intent to destroy the targeted group. Again, I think this is very important in the context of the discussions we're having about ethnic cleansing and genocide. Ethnic cleansing, he says, and genocide, rather than excluding each other, again, this is very important for the genocide case in Gaza, appears to be somehow overlapping. With the growth of extreme violence, what at first appeared to be ethnic cleansing turns out to be genocide. Initial intent to remove degenerates into intent to destroy. In such circumstances, there is no sense in trying to camouflage genocide with the use of the expression ethnic cleansing. In some circumstances, such an expression may well amount to genocide as reckoned by the ECHR in Georgia, Germany. So this I think is something that Brazil can contribute to the discussion, right? Because like right now we have this world where people want to say it's either ethnic cleansing or genocide, can't be both. And what Cançado Trindade is saying here, and what I think Brazil should recover from this dissent and say, hey, this makes more sense, is ethnic cleansing is a way to carry out a genocide. Sure, there are circumstances where ethnic cleansing would not be genocidal. We discussed this in our previous video. Like if Donald Trump tomorrow decides to expel every single foreigner from the United States, it would be ethnically cleansing the United States of, say, like Latin Americans. That would not necessarily be genocidal because it's a process of mass deportations, as opposed to a process of like mass killings and the objective of destroying the group as such. Sure. But this world where ethnic cleansing and genocide are opposites should stop existing. We should not be living in that world. On the contrary, if you see ethnic cleansing, your alarms for genocide should go on and say, oh, this is probably a genocide. It may be that it isn't. Maybe it's Trump just deporting Latin Americans. But in most cases where it involves violence, ethnic cleansing would be genocide. And I feel like this is what Brazil can bring to the table, because this is Brazil's most famous lawyer, at least of the modern times. Very influential guy in Latin America, and not as influential outside of Latin America, but very influential as a Brazilian. And so if I were thinking about intervening in the context of this as Brazil, this is the tradition that I would bring into the discussion, sort of as throwing a monkey wrench into the discussions of the only reasonable inference test, and saying, look, sure, we can find genocide even with the only reasonable inference case, but that test is a problem. It's an invention by a court that narrowed the definition of genocide, unjustifiably so, and we need to rescue the definition of genocide from that standard. And I feel like Brazil is in a unique position to do this. If I could advise them to do something, that's what I would advise them to do. To bring this tradition back into the case and to push back against what the court did in 2007, 2015. Because right now, what most people are doing is saying, we don't need to push back. We will push back a little bit, but we don't need to push back. With the standard, with the law as it is, we can manage. And I want people to say, no, the law as it is sucks. We need to change it. Like, not even change it. We need to change we need to recover a workable definition of genocide. Because, this common expression is, if everything is genocide, then nothing is genocide, right? If we start calling everything, single little thing that happened a genocide, then genocide will lose its gravitas and nothing will be genocidal. And that's wrong. We shouldn't do that, right? I think it's the other way around. Right now, what we have is a set of rules, a set of tests invented by the ICJ in 2007 and 2015 that make it so that nothing is ever genocide. Serbia was not genocide. Apartheid is not genocide. Jim Crow is not genocide. Gaza is not genocide. Nothing is genocide. Nothing can be genocide. And that is just unacceptable, right? So I would wish for Brazil in this context, this geopolitical context, where Brazil is trying to create a post-Western world, to bring forth this tradition back into the table of the ICJ case and say, look, yes, we don't really need to change the standard because Israel's conduct is that horrible that even with this super narrow standard, we can still find genocide. But let's accept that that test, that standard, the only reasonable inference standard, is a flawed one. It's an invention by a court that didn't want to find genocide. It was too politically unsavory. Or at least it wasn't brave enough to find genocide and failed the victims of genocide, right? And we are here at the brink of once again failing victims of genocide. So why did I get so excited when I heard that Brazil was going to participate and join South Africa's case? Well, because of the geopolitical context in which Brazil is, it has every incentive to throw a monkey wrench into the existing global order. And this case is something, it's like a unique opportunity for Brazil to do that. And so I really, really, really hope that that's what they do, that they grab Cançado Trindade's dissent and turn it into Brazil's application. Well, not exactly, right? Do a good job in adapting it to the Gaza case. But this kind of reasoning, this kind of like victim-centered reasoning is important to incorporate into the discussion. And it would be a great, homage to Judge Cançado Trindade, who is a giant of Latin American international law. And like we should rescue this tradition of international law, not as a state-centric body of rules, but actually as a body of rules that is meant to protect people from states, right? And that was Cançado Trindade's life mission, life goals, and I think it's a valuable one. And I think Brazil is at a perfect moment to carry out this promise here that Celso Amorim said in this article. Says Brazil was not conceived as a rival of G7, but G7, the BRICS are more and more offering something that the old order does not achieve: inclusion instead of exclusion, reform instead of stagnation. So do that, but with the genocide case in Gaza, right? That's my objective. That's what I want. So Chirimbolo167 says, how hopeful are you that Brazil will do that? I don't know. I don't have any insights here. I'm just like expressing my excitement at the possibility that they do that, because I think the government has every opportunity. Like the government is in the right mindset to do this, and this opinion is very well known among Latin Americans. So fingers crossed they do that, right? Okay, guys, it's 7 p.m., which means, as always, that I need to go cook dinner.